you are the appellant and wish to reserve up to 5 minutes for rebuttal time, please let me know and we will accommodate you. Our first case this morning is Mantabs versus the Happy Fiddler Association. Mr. Ellis.
Thank you, Your Honor. My name is Jonathan Ellis. Seated with me is Kathleen Raris and Dwayne Geiger of Shoemaker. We have the pleasure of representing Mantabs. Brian Hull and Webb Melton are representing the association. We're here today primarily on an issue of a unit within an association owned by Mantabs and the Salins, which had a substantial use of a balcony for approximately 25 years by the Salins, approximately 32 years by their predecessors, and all of a sudden that use was removed by the association. There were a number of complaints that were filed and combined. The procedural history is somewhat tortuous, but it's not that complex for this court. We're dealing with the declaratory action filed by the association and count 7 of the association's counterclaim. Court issued summary judgment through a number of different orders for on behalf of the association, resulted in this appeal. I think this is the 3rd time before the court, the other 2 having been based on non-final orders. Mantabs had used this balcony that they believe and is in fact part of their unit. And they do that, or you get to that determination by actually looking at the text itself, except for the fact that when you look at the text itself is clearly not clear. There's a number of different references to which the balcony is referred to, or the terrace, depending which part you look at.
But if the declaration refers to a balcony and a roof terrace, and as I understand it, I've read through this, that is shown in the drawings. There is what I'll call the porch. And part of it is covered and part of it extends into the sunlight. That's shown on the drawings, correct?
I don't think it's shown as exactly being covered, but there are different pictures in the different drawings. So if you look at the plat, which is Exhibit A, that shows you where it indicates sun deck. And that shows the entire piece being sun deck, not divided into 2 separate pieces.
And that does not have the roof.
That doesn't.
To the, I guess that's the north side.
No, it does. It shows the roof to the 3rd floor. So it shows 2 items. It shows roof over the 3rd floor, and it shows sun deck. And the issue that I think, reading the understanding the arguments of the association, is that the sun deck isn't 1 terrace. It's actually 2 terraces. And that's the argument that's being made by the association. Now, the association bases its argument that it's 2 terraces on different diagrams. But if you look at the different diagrams, none of the diagrams upon which they base their argument show at all that the sun deck is supposed to be 2 separate individual
Explain the
pieces.
importance of that. Is that because of the plural word terraces? That
No, so if you
explain the
look,
importance to the fact that sun deck is not bifurcated into 2 sections in your interpretation of the images and the language.
the importance is it shows that it's 1 item. It would have been easily placed into 2 different documents, and it's placed twice if you look at it. Once as a sun deck, and another time in the blueprints. The only time is opposing counsel argues that it's really 2 separate terraces is by taking 2 different pictures or 2 different diagrams and saying this diagram refers to, for instance, a sun deck, and another document or picture shows a patio, and then you wind up having a sun deck and a roof patio, but never. And when you look through the diagrams that are shown, are those ever shown in the same diagram? When you're looking at it in the same diagram, it only shows as one item.
Well, let's get a little more clear here. It says roof over third floor. Roof, it doesn't say terrace over third floor. Plus, it had been replaced in 2007 by the association, not by your clients. There's nothing in the DOC that says they have an ownership interest in the roof over the third floor. Your clients just went ahead and, God bless them, they built a terrace, they put pallets down, they put gazebos. But and you've been using this word, I think you're using it strategically, but you said use. You haven't said your clients own any, they use it. So where is it in the DOC that they own this roof?
I think when you look at it, this is the exact area, I would tell you, Your Honor, would be in section 4.3 of the declaration, which talks about two terraces, a balcony terrace and then a roof terrace on the roof adjoining the apartment. That's in
But
section.
the DOC doesn't say roof terrace on the diagram.
It doesn't say roof terrace on the diagram, but you can look at every diagram that's being cited, and there's not a single diagram that says roof terrace. And that's the problem, is if the diagrams don't use the same terminology that the deck uses in itself. So you wind up having different language on the diagram. So if you were to
understand why your clients claim ownership interest in this roof and they refuse to repair it. And they refused access for repairs. It's kind of inconsistent.
Well, I think the roof, Your Honor, is a common element of the association. The roof itself, the membrane itself is a common element. I don't think there's a
The
dispute.
floor of the terrace your clients built is.
The floor,
On top of the roof.
correct, just like the slab on a condominium is a common element, but the wood floor that's placed over the slab is owned by the unit owner and within the parametrical boundaries. So when you read it, you talk about the parametrical boundaries, they talk about two terraces. Now that has two readings, I think it's.
But the roof, which I'll refer to as number 3 diagram, there was no license, no permit to build the gazebo and flooring up there on a roof that you recognize owned by the association. The drawings do not show the cut in the concrete that I guess your clients access the roof. I'm just trying to make sense between what they claim is some interest in the gazebo with what is in the drawings as part of the declarations.
So I don't think when you read this, you can fully coordinate the drawings with the language in the deck. There's just a disconnect. So what is their interest or why can they claim? This gets into a level if you find it. If you find that the deck and the drawings and everything are clear, I don't think you go to parole evidence. But to the extent it's messy and it's questionable, then you wind up in parole evidence. You go to parole evidence, one, you have the developer that's indicated they owned it and this is what they intended. You have the developer saying.
What did they own? Let's go back to Judge Sleet's question. What did they own?
They own the surface right above the roof system itself, just like you would own the flooring or the carpeting right over the slab. So when you deal with the
But does Mr. McCandless's affidavit specifically say that the unit owners in 401, 404, which could have been 301, 304, own it? Because I looked at his affidavit and clearly asserts have exclusive use. You would agree legally, exclusive use and ownership are two different legal concepts.
I would agree that use,
Is that a yes or no?
that's a yes. They're two different concepts. So he does not own the roof, but when you get into where the parametrical boundaries are, you deal with the description of the unit. Look, the answer is that when you're dealing with two terraces, a balcony terrace and the terrace adjoining the roof are really one sun deck, where no other document shows those together.
That's not, I have trouble with that because getting to what I call the porch, you access that through one of the bedrooms, or you access it through the sunken, what I'll call family room. There is no direct egress from the unit to what you call three, the roof.
There is,
You have to go through this cut in the wall that was not shown in the original drawings.
correct.
Okay.
That is an accurate statement. You have to go through the cut in that wall. If you go to the affidavits of the, and again, we're into pro evidence, you go to the affidavits of the developer, which should be considered to the extent, and it's actually outcome determinative, to the extent this court believes parole evidence should be used, then those were cut specifically to allow use of that area over the roof, over the third floor.
Apparently, nobody told the architect or the contractor.
Nobody may have told the architect or the contractor, notwithstanding the architect's diagrams don't control. There's a number of changes that can be made after the drawings are done and you're building the building.
But the drawings and diagrams are part and parcel of the declaration.
I think when you look at exhibit A and you look at exhibit B, the answer is yes. When you look at the architectural diagrams, those are not. So the exhibit A and exhibit B are. Neither exhibit A nor exhibit B indicate or use the word terrace or give any type of idea where that terrace is. The only way we get to this idea that there's a terrace is that there's a picture that's placed in from an aerial aspect where somebody has unilaterally sort of drawn a line, even though it indicates that's divided in two. That's not part of the decks. That is not part of the any of the diagrams. It doesn't use the terms that are set forth in the deck or the diagrams itself. And
I
that's
just want to make sure I understand. There is no direct access to the roof from the inside of 404.
if you're asking me that little piece of the room on that one corner when you're looking at A, I don't know, that does not, I don't believe, have a door directly onto the roof over the third floor.
Okay.
That's what you're asking. I don't believe there is any door to that. You have to go to the sun deck, and then you go over the knee wall.
Okay.
Now, the aspect is when it was purchased, this was a balcony that had pallets on it. So the person who purchased it, which happened to be the developer, but there was an equal aspect on the other side, both had use, and these items were installed by the developer. And that has special meaning when you're.
But subsequent history shows that that roof was not sufficient to hold those pallets and gazebo.
Well, I think it was sufficient for approximately 25 years to hold those pallets and those gazebos. Then you wound up having a problem after some 25 years. And then they wound up putting a new roof on, put a roof on that didn't support these pallets. And then all of a sudden you have this issue. Those pallets were on there and those balconies existed for some 25 plus years. Both the predecessors of Mantabs and then from Mantabs, which both had exclusive use. Now, to the question is, were they responsible for maintaining the roof membrane? No, there was a dispute on whether they were responsible for maintaining the pallets, and you see the correspondence from Association Council, which indicated that they were responsible for it, even though Mr. Salem, I think at the time, took the position he was not responsible for it, notwithstanding these, Mr. Salem's position is not governing, but under condominium law, it's clear that if you got a roof, developed or installed improvements to do a fix, then you were responsible as an association for putting back the developer installed improvements. So if the developer put in a specific type of floor and you have to get to the slab and you remove that floor, you're responsible for repairing that floor. That's different in a situation where you wind up having an improvement or a betterment of the floor.
But I got the impression in your brief that that exchange of correspondence showed your client's interest, whatever it was, in the roof. And I sense a shift. What the dispute was really about is who had to repair the wooden planks and the gazebo. after the roof?
I think there was an aspect over who was supposed to repair it. In reality, I think to the extent these were developer installed improvements, regardless of who owned it, they had to be replaced just under basic condominium law. You wind up with a material alteration, and we've cited certain arbitration decisions say after you change it, you've got to put it back. You get the accoutrements that go along with the accoutrements that wind up dealing with your property. And in fact, there's even amendments if you want to make a material alteration, which changing the third floor roof would be a material alteration.
So at no time during that dispute, did Mr. Salem, if I'm correctly identifying him, make the argument against responsibility for performing repairs that space above the roof was common element?
I would like to tell you that it might be the case, but it's not. He clearly indicated that he is not responsible. The association should and is responsible for maintaining that area.
Is the position he took that it was at that time that it was a common element?
No, I think he took the position that this was his property and that the association was responsible for it. 5.1 of the deck says the association maintain the balconies, notwithstanding. And if they're going to maintain the balconies, then if you're removing these areas, you need to reinstall them. But I think when you look at it from a legal standpoint, the answer is that if these were placed by the developer, pallets, gazebos, and you re-roof the floor, you re-roof the membrane, you got to return it to the way it was.
Mr. Ellis, excuse me for interrupting you. You're a little bit over 16 minutes into your argument.
I'll stop at this point and save for rebuttal. Let's just bench a specific question.
Thank you. We'll give you 4 minutes for rebuttal.
Thank you.
Thank you. Good morning. Go ahead.
Thank you, Your Honor. Good morning, may it please the court. I'm Brian Hall on behalf of the Appalachia Happy Fiddler Condominium Association, Inc. This declaration is not ambiguous. The roof over the third floor and the airspace above it is a common element that belongs to all of the unit owners and not just unit 404. And as a common element, the association has an obligation to maintain the roof over third floor to prevent flooding into the units below. The association has not said the appellants cannot use the roof over the third floor. They have the same use rights as all of the other owners. But nothing in the declaration purports to grant the roof over the third floor to unit 404.
Is there anything in the record that suggests that any other unit, or any owner of any other unit attempted to use that space?
I don't believe there's anything in the record that addresses that particular issue. For several decades, the Condominium Act has imposed specific requirements for what must be in a declaration. And in 1973, when this declaration was recorded, those requirements were codified in Florida Statute 711.0820. And that says, just as it says today in a different section, that a declaration must have a graphic description of the improvements in which the units are located and a plot plan thereof, which together with a declaration are in sufficient detail to identify the common elements and each unit and their relative locations and approximate dimensions. And here the units are described in both the declaration's text and in its exhibits. And the text of the declaration, which is where the appellants have focused their argument, has the section 4.3, which describes what they call the typical apartment floor plans. And for unit 404, which is the one we're talking about here, it does describe a balcony parentheses terrace and a roof terrace on the roof adjoining the apartment.
Why doesn't that create an ambiguity?
That does not create an ambiguity because that does not show where that space is located, and it does not show the approximate size or dimensions of those particular areas.
Is it incumbent upon you to identify two spaces other than the space at issue that could be, to which could be ascribed the term balcony terrace and roof terrace.
Yes, and I believe we have done that. When you take the two exhibits together, Exhibit A and Exhibit B, they show two very distinct spaces. And I can get to those right now, where I can address the particular issue as to whether the roof is a common element. I'm happy to
Not
take
sure
it.
why they're not related, but.
Of course, well, as I mentioned, there's nothing in section 4.3 of the rest of the text that says where those spaces are located. So you have to look to those exhibits to show where to find those spaces. And there's also nothing in the text of 4.3 or the rest of the declaration text that says whether those terraces are connected or separate spaces. 4.3 also,
From each other?
whether they're connected to each other or whether they're two areas that are completely separate in separate locations.
Except it says the roof adjoining the apartment.
Yes, it does. And both of the spaces shown on Exhibit A and Exhibit B indicated as the roof patio and as
You
the
walk
sun.
right out onto what you would call part of the unit, that is also a roof adjoining the apartment.
That does sit atop the roof
Well,
on the units below.
I will, take judicial notice that the third floor is above the second. For that reason.
Section 4.3 also says how it is to be interpreted in connection with the rest of the declaration. It says these apartments are described generally below, but reference should be made to the plans, which are the exhibits. And the two exhibits do indeed show the relative locations and approximate dimensions of the unit and both of those outdoor spaces. Declaration Exhibit A, which is the plat, shows the exterior walls and the boundaries of the units, the outdoor spaces, and the common elements.
We've seen this in the record in the brief. I assume Mr. Ellis has no objection to.
It's going to be beneficial before we have no objection.
Thank you. Go ahead.
And this shows the fourth floor from Exhibit A. The other floors are shown on earlier pages. It appears several places in the record. And to put this into context, on every single floor, the outdoor spaces are labeled with words that describe outdoor spaces belonging to a unit. On the first floor, it shows a CP, which it says it's got covered patio. Second floor units have a CB or covered balcony. And on the fourth floor, it has sun deck. All of the outdoor spaces, everywhere they're shown on Exhibit A, are enclosed in a solid line, indicating finished flooring of a patio or balcony or outdoor space. The space at issue here, the roof over the third floor, is not marked as a patio, a balcony, a sun deck, or any other outdoor space. It's enclosed with dashed lines indicating a roof, not a finished floor of any sort of outdoor space. And it has no approximate dimensions or square footage on that space.
Let me ask you this, because 4.3 clearly says roof terrace on the roof, adjoining the apartment. The diagram says roof over third floor. So we have two roofs. So we have a sun deck. So tell me why that's not ambiguous. What do I need to look? So I look over at the diagram. I've got the clear language here. I look at the diagram and I see roof over third floor, but I also see roof terrace. Does that mean equal evidence?
I say that it does not, and the reason is this clearly only says roof. It says no outdoor space exists above it, and the area marked sun deck is on the same horizontal plane there, and it sits atop the roof of the third floor units directly below.
Where's the roof terrace that 301, 304 have access?
Sure.
On that diagram.
On this diagram, they have access to the two terraces. Both are included within the area referenced as sun deck, and when you take the two exhibits together, Exhibit A and Exhibit B, it shows the two distinct areas.
Okay. One would ask why didn't it say roof terrace instead of sun deck?
It does, and in other places, like where it said covered patio, for example, they use different language in the declaration as well, and between the declaration exhibits. I don't know why they use different words, but that's what they use. But we would submit that the Exhibit A is not ambiguous about the roof over the third floor. It is a roof and nothing more on Exhibit A.
But Mr. Livesey purchased it as is. Is that correct? And it wasn't until the owners of units 301 and 304 they decided to build and enhance the floor over the roof?
I don't know at what exact point the decking was put down. It may have been put down by the developer. The developer did own that unit. But the mere fact that he may have put down decking on it or even cut a.
Whether it was there before or he put it there, doesn't matter.
That it does not matter because it's the declaration that establishes exactly what the unit owners own. And the declaration was never amended. He owned the unit and could have amended the declaration, He even gave himself a very easy procedure to amend the declaration and never did that. Never did that to make that area distinctly his.
You said that diagram, at least the conclusion that it is unambiguous that is a roof over the third floor, and that's what it says, but would you concede that it is a roof adjoining the apartment?
This would adjoin the apartment and it is indeed a roof, but there's nothing that makes it a roof.
So what is
Terrace.
the unambiguous conclusion again?
That the roof over the third floor is just that, it is roof, so that makes it a common element.
What is it? So a roof adjoining the apartment?
It does adjoin the apartment, the roof space does, but it's not a terrace.
You could just-
Go ahead, Josh.
I guess you could just as easily say it abuts that separating wall.
That is correct.
So the roof is distinct and apart from the unit because of that wall, because the original drawings do not show a cut.
That is correct.
So can you go back to the issue with the fact there are two separate porches, as Judge Rose termed it, to add more term. Let's go to that.
Absolutely.
Where are the two separate?
Absolutely. The second space, the second distinct space is described on the declaration Exhibit B. And here, as with all of the other outdoor spaces described on declaration Exhibit B, a grid pattern shows where the outdoor space is. And at the bottom, it says the square footage. And here we have a 213 square foot roof patio. There are lines that extend, in this case, to the west upward, but there are no lines and nothing indicating any sort of outdoor space to the right, to the north, which is that roof over third floor area. It is 213 square feet. It is undisputed, and the record shows that 213 square foot roof patio area is covered space. And in fact, for unit 401, it has been enclosed, and so it's enclosed air conditioned space. So that is the roof patio that appears on Exhibit B.
And the roof in question that we're talking about is the roof over the second floor, correct? Does it cover a living space below?
Yes, it does.
So the second floor folks can't do without that roof.
That is correct. The second floor units are actually townhome units, so it rises to the third
No,
floor.
that's their roof.
It is their roof, absolutely. The only way to interpret the declaration that does not violate several rules of construction is that these two spaces, is that these are two different outdoor spaces. See, the problem with reading the declaration to grant the roof over the third floor to unit 404 is that it construes the text only without giving effect to the exhibits. It renders meaningless the words roof over the third floor on Exhibit A, and it ignores the lack of additional outdoor space on Exhibit B to the north or to the right. And it would interpret the declaration in a manner that violates section 711.081E by not showing the relative dimensions or square footage of that roof over the third floor space.
Help me solve something that you designated that as sun deck. The declaration refers to a balcony and a roof terrace. What are we talking about? Are you telling me that the sun deck is indeed the balcony / roof terrace?
It doesn't matter which is which because it's not clear which is which. We would submit that the balcony terrace is this additional portion that is beyond the roof patio.
I thought it was the opposite. The balcony terrace is the covered portion depicted on the declaration to the B, and then the roof terrace is the uncovered portion that extends, as I look at it, upward and into the B.
Again, it doesn't matter which.
Well,
is which.
it doesn't matter, but
It's two
does it,
distinct.
because you have to identify, isn't it incumbent on you to, contending that this is unambiguous, you have to identify the two porches. Or do you not? In other words, if it's unambiguous, don't you need to show us which porch is which? And to that end, I want to ask, so you made a compelling point about the fact that space, the grid square space, matches the square footage. But if the balance of the sun deck, is it possible to, I can't remember what we said for briefs, but is it possible that the balance of the sun deck also matches the description of square footage? So as to establish that is the roof terrace?
Unfortunately, there's no precise square footage measurement for the
That would be-
additional
that would
portion
be
of the
too
sun deck.
much.
By math, we could easily get there. We have a 30-foot by 14-foot sun deck. And here
Right,
we
so
have
let's
what's
reverse
clearly,
engineer it and then,
clearly 213 square feet, so that would leave a 207 square foot uncovered sun deck space.
is that 207 square foot? Search your briefs. And see if they look up. Tell me, does it match any written description?
Unfortunately, it does not. I wish that it did. It would make everyone's life a whole lot easier.
Not for the FLNs, but it would be nice for resolution.
Of course. So those two spaces adjoin the unit. They sit atop the roof of the third floor below, and they're both marked as outdoor spaces, distinct outdoor spaces. It has the approximate dimensions and the relative locations of both, which is exactly what the Condominium Act requires. The declaration also specifically referenced the architect's plans, said the improvements would be constructed substantially in accordance with those plans. The plans named the two different areas, the roof patio and the sun deck, and we pointed to a brief where it does that. They show the space to the north or right of the unit marked as the third floor roof, not as any sort of outdoor usable space. And it shows, as Judge Rose recognized, a complete unbroken knee wall with no cutouts. That these are two separate but connected spaces is the only way to give effect to both the text and the exhibits of the declarations, which give the specifics of what the units and their outdoor spaces are. It's the only way to give effect to the words roof over the third floor on Exhibit A. It's the only way to give effect to this measurement of 213 square feet on Exhibit B. And it's the only way to give effect to the absence of anything denominating an outdoor space to the north or to the right of the unit on Exhibit B.
So the fact that there is a separate measurement, 213 square feet, gives rise to the plausibility of the conclusion that the sun deck in A is bifurcated. Not to mention that it seems bifurcated, those little rectangular portions extending north upward on B are not square, they're rectangles, and so therefore presumably it's a different space.
Presumably, this does appear several different places in the record, and being as old as they are, some pictures are better than others and clearer than others, and I believe it may actually appear to be square spaces in some of the other areas.
Okay, well, then never mind. But it seems to me you must be relying on the fact that what appears to be one continuous space declaration A is in fact bifurcated by virtue of the calculation of 213 square feet, which wouldn't cover the entire sun deck.
That is correct, and also by virtue of the plans which were specifically referenced in the declaration. And the declaration said that it would be constructed substantially according to those plans. Those plans do indeed label the two different areas.
So the only thing remaining for you to explain is why the remainder of the sun deck cannot be considered the adjoining roof along with the rest of the adjoining roof. And your answer, I'm assuming, is going to be that wall.
That is exactly right. Not only the wall, but that's the only space that's labeled as outdoor space. The rest of it is labeled as roof and nothing more than roof. This is not a case where extrinsic evidence is appropriately considered. Boundaries of a unit must be based on the declaration itself. And that declaration has to be strictly construed, construing all parts, including the exhibits. And the declaration itself says the text, section 4.3 and the other sections is only general, and that we must look to the exhibits for the specifics. We cited the Shores of Panama case from the First District Court of Appeal in our brief that addressed a dispute over the boundaries of a unit. And there, just like here, we had a declaration that describes the units in several different ways, including text, pictures, and square footage. And some of those descriptions left it unclear as to what the boundaries were. And in that case, Judge Wolf looked to the most specific description of the units, which he found to be the square footage, and held that that's what would control. And here, the declaration tells us what is the most specific description of the units, and that's what appears in the exhibits. And that's what controls here. I did want to address briefly, in my remaining time, the issues of estoppel and these unpled claims and defenses. The appellant's estoppel defense was a very narrow defense when pled. The first affirmative defense only said the association was stopped from asserting a claim that the roof over third floor is a common element. And the trial court rejected that in its second summary judgment order. They now say that the association is only stopped from removing or replacing roof property, which is the gazebo and those sorts of things, or that the association is stopped from maintaining a roof in a way that changes the original use of the space. The problem with that argument is the same problem they have with their third argument, that the trial court did not issue a declaratory judgment to the same effect. And that problem is that they did not plead these claims or defenses. What they actually alleged was very narrow in scope. They sought to amend their counterclaim to add count 8 to raise those issues, but they withdrew that. The trial court denied leave to amend to add those claims, and they don't challenge that issue on appeal. They pointed to the association's complaint, but that also did not involve the issue because the association only sought a declaration as to who was responsible to maintain the roof, not how it was to be maintained. For the first time in their reply brief, they say these claims were tried by consent, but the rule is specific to trials, doesn't deal with summary judgment. In our brief, we cited several cases that say you cannot raise unpled claims or defenses on summary judgment. In this case, they dismissed all their remaining counterclaims with prejudice, submitted a jointly submitted an agreed order that said there are no further matters to be resolved by the court as all claims and counts have been resolved by dismissal with prejudice or final judgment. And their notice of appeal also said that counts were not resolved in the final judgment that had been dismissed with prejudice. These issues were never pleaded. The trial court did not abuse its discretion by not addressing them. So there's no reason to remand to address those issues. So in the end, what the appellants really want is to own or have exclusive use of the roof over the third floor, but they want the other unit owners to pay for it. 3 trial judges decided and redecided this issue, and they all got it right. The declaration makes the roof over the third floor and the airspace above it a common element. It is not part of Unit 404. The judgment should be affirmed.
Thank you, Mr. Hall.
Thank you.
Mr. Ellis, 4 minutes.
Sure, let me just point out, when we get to,
Do you need these exhibits?
I don't need them, but if you're looking at exhibit B, I can take it down if you read.
I was just, well,
I'm
I'm
happy
asked Mr. Hall if we take them down.
So if you're looking at exhibit B that has the hashtags and you do the math, because all you need to do the math is to look at.
Mr. Hall, leave the second one up if you would. I'm sorry, but it had the hash.
If you look at the one that says sundown, and you can determine exactly what that is by where the corners are in the measurements, and you do the math on it and you multiply the one line by the other, you don't get 213 feet. You get 200 feet, 200 point, I think, 6.
So I want to be clear with this. So there's, the sun deck is what, 30 by, I can't do that, 30 by 14. Isn't answer your kind of reply to this, isn't what's important that there, of the sun deck, a space smaller than the 30 by 14, some of the 30 by 14 space is set out and apart from presumably the other portion of the sun deck by the declaration by virtue of the mention of 213 square feet. Doesn't that do what the appellees need to do in order to establish that the sun deck is actually treated as 2 separate spaces
No, you don't know where that goes. It sort of shows it goes on at a certain point. The math doesn't add up. The math very well.
Tell me why the math doesn't add up.
Well, if you add it up, Your Honor, you take this argument and you would multiply, for instance, 15.67, which is this line here, and 14 feet here, it doesn't equal the
Well,
200.
that could be just because there might have been an overhang of the covering extended. a
There
little
could be,
further.
there could be,
Is it more or less?
it is less than that. It's 200.6
The range
feet.
goes more.
What? No, I'm just saying, it's confusing. The, and keep in
Well, you
mind,
would concede that there is, that space is bifurcated by the language of the declaration by virtue of a square footage that is less than the square footage of the sun deck as depicted on that.
I think what it's indicating is that on what's shown is 213 feet. That doesn't mean that this document or this sun deck means nothing. And it doesn't mean that all of a sudden these meanings that are set forth in the declaration, such as adjoining roof, now becomes something that's the second half of the sun deck and doesn't happen to be referenced in some diagram that doesn't show the entire parametrical boundaries of the document. And in fact, when you look at 5.3, it specifically indicates, it goes out of its way to say not only does it include this area, but that it, give me a minute, that it includes it includes the balcony terrace, and it includes the roof terrace on the roof adjoining the apartment. And they go out of a specific way to say it not only includes that. When you talk about the common elements, it specifically says, except the roof terraces include the parametrical boundaries of the penthouse apartments. And that's dealing with the roof terraces. So you got to make a special exception for these two penthouse units. Now, keep in mind, it was the developer, and these are the affidavits, it's not disputed, that actually cut the knee-hole wall and put in these improvements on this balcony. And why is that important? That's important because when the developer installs an improvement, people who buy the units get that improvement or get those accoutrements. That's why you can't change the color of the
Well, you could
condominium.
just add a hot tub to the common area and make it use of it.
Anybody gets the use of it, but now all of a sudden you wind up having a developer install it, you have it removed without 75% vote of the unit, the unit owners of the association. When you have specific requirements in the decks, what's required to remove a common element. So if you accept the argument of the association, you just can't remove these without three things taking place. Number one, it has to be by 75% of the unit owners. Number two, the people that are not supporting it don't have to pay for it. And number three, can't affect the accoutrements of the unit. And this clearly affects you looking out on a balcony patio that you can use over the entire roof of the third floor, installed by the developer. I mean, that was there when they went by the developer. It wasn't something that each unit owner put on identical in 401 and 403 in the, or 404 in these situations. This was installed by the developer. Now it's there in a usable space that has to go through a certain procedure to remove and not reinstall. I think there was a question, hey, why did Mr. Salem dispute the repair of the balcony? That's because in paragraph 5.1 of the declaration, it specifically states that the association is responsible for repairing its balconies.
With that, Mr. Ellis, you're gonna have to wrap it up.
Okay. The last thing I want to go, but this is so unequivocally clear as the association takes the position. I wanted to remind the court, this wasn't an action for enforcement, it was really an action for declaration. It was a declaratory action, which generally says to the court, we don't really know what the answer is, we need you to tell us. Meaning it's confusing, there's different ways, and if you read it, it's not done as a straight action, it's done as a deck action. They're asking for advice from the court. If this was so clear, it would have been an affirmative injunction claim or something along those lines to stop use of the third floor to determine the maintenance aspects of that property. But it was done as a deck, and it was done as a deck.
Mr. Ellis.
Thank you.
Mr. Ellis, thank you, Mr. Paul, thank you for breaking this back. Our next case this morning is Critical Reproductive Services versus